Assalamu alaikum warahmatullahi wabarakatuh. Today, my group and I will be discussing or presenting about the topic of alternate dispute resolution. Our topic given was advantages of ADR, and we'll be discussing the themes around the topic itself. So let's introduce ourselves. My name is Nik Akideo bin Nik Muhammad Rusdi, matrix number 1922009, and my group members are 1 Mashito binti 1 Azhar 1916560 and Nurul Shafika binti Azhar 2018488. And the contents of our overview, you can see here, we will be talking about the definition and general understanding of ADR, the modes of ADR, advantages of ADR, some disadvantages of litigation, and we will be discussing a bit about the whole topic later on as a conclusion. So first off, we have to understand what is alternate dispute resolution, also known as ADR. Well, ADR is an alternate method for resolving legal disputes among parties or between parties without needing to go into court. Typically, people would think that businesses would just straight up sue one another because of a dispute. This does happen, however, it's not normal, it's not common. Typically, businesses would first engage in ADR before, if they cannot settle the problem right then they then bring it into court. So to talk a bit about its historical value, the use of ADR has been pretty much seen throughout history. Many civilizations have used this form of settlement. For example, many religions, but also notably the Islamic Empire, whereby Muslims were encouraged by God to follow the Sharia and to settle their disputes without going to court. So that means that they did have a lot of ADR during that time. And some of the questions that people might ask is whether civil or common law. Well, both civil and common law legal systems identify ADR as a proper way of settling disputes rather than litigation. We have, for example, the overall mechanisms of ADR, such as mediation, arbitration, conciliation, and, for example, the civil legal system, they would have mini trials too. The scale of ADR is not necessarily limited to just on a national level, like for example against individuals. However, it can also be pertaining from state, for example, when it comes to international level, like countries versus other countries. Typically, like to give an example, Muslim countries would normally have disputes, and the mediator would typically be Iran. Iran will come in and mediate for these countries and try to settle the dispute before having a huge problem there and then. Okay, so to move on to the next topic or the subtopic.
Assalamualaikum warahmatullahi wabarakatuh. My name is Wan Mashtamatu Azhar, matric number 1916560. Now I'm going to present about the mode of alternative dispute resolution. So there are many methods of alternative dispute resolution, but the most common method are arbitration and mediation. However, party may choose the method that are suitable for the circumstances the most. Therefore, I will talk about a few modes of ADR such as arbitration, mediation, settlement agreement, and mini trials. So let's take a look at arbitration. Arbitration is defined as a voluntary dispute resolution process in which one or more arbitrators appointed in accordance with the agreement of the parties or rules promulgated pursuant to this act resolve a dispute by rendering an award. In the case of Collins versus Collins, Sir John Romilly MR stated that arbitration is a reference to the decision of one or more persons, either with or without an umpire, of some matter or matters indifferent between parties. In Malaysia, arbitration proceedings are regulated by the Arbitration Act 2005, which came into force on 50 March 2006. In this act, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. It's also stated that there must be an agreement of the parties must be ad idem. Second, the agreement must be in writing. And third, there must be an intention of parties to have different referred and decided quasi-judicially. Therefore, we can see that parties often seek arbitration method rather than other litigation because of numerous reasons in which I will discuss later in depth.
Now let's talk about modes of ADR in terms of mediation. Mediation is defined as a procedure when the parties discuss their disputes with the assistance of trained impartial third persons who assist them in reaching a settlement. Mediation may be an informal meeting among the parties and dispute that either are pending in court or potentially a dispute may be filed in court. It is said that mediation is suitable in some certain types of cases or situations whereby it involves personal injury, commercial transactions, workers' compensation, construction, labor or community relations, domestic relations, divorce, employment, and other matters that don't necessarily involve a complex procedural or things which have an evidence type of issue. Now let's talk about the mediator. What is a mediator? A mediator is a specially trained person that helps disputants or the parties to reach a settlement. The mediator is a person who is supposedly to be unbiased, a third person, that is brought in to resolve any misunderstandings between the parties, and the decision of the mediator is not legally binding in courts. Of course, unlike the arbitrator, sorry. The mediator is the manager of the mediation process. It's just a person to look out for the whole dispute overall. They help both parties to explore their options in a private and non-confrontational environment that will make them have pretty much there's no pressure on these parties to in this type of situation. There's less of it compared to every other ADR. In many jurisdictions, the mediator is an attorney but cannot give legal advice within the role of a mediator. The mediator's field area of expertise can be beneficial to the parties in wording and in framing the mediated agreement or in circumstances where the parties are receptive to neutral case evaluation. So they also can appoint more than one mediator during a mediation session. The mediation process can be divided into 5 stages, whereby after the appointment of a mediator, parties are acquired to or required to attend a pre-meditation conference whereby the mediator will meet with the other parties for the first time and explain the whole mediation process and disclose any potential or actual conflict of interest at hand. The mediator also can request the parties to provide a summary of facts and relevant documents. And at the end of the premeditation conference, both parties can are required to sign an agreement to mediate or to have the mediator to mediate. Sorry. There are no legal penalties for failing to settle at mediation. The court can order there may be penalties for failing to attend the mediation conference, maybe also not having good faith to settle the case. When the parties fail to settle the case, it may be recorded in an administrative agency or court of competent jurisdiction, and it can be set for the next action that is beneath the forum's procedure. The only report of an successful mediation is referral back by the mediator himself to the court or the organization for further processing. Of course, there are numerous reasons why a party might want to have a mediation compared to any other ADR or even litigation. This is because mediation is less stress, as there is no third party when it comes to deciding the judgment at the end. It is only an agreement or a dispute or a conversation of trying to resolve the dispute among two people, no third party. The mediator only acts as a person who helps in this process.
Next is mini trial. So mini trial is a method of resolving dispute in which the merits of a case are argued before a panel comprising senior decision makers with or without the presence of neutral third person, after which the party seeks a negotiated settlement. So when they are presenting the case, expert witnesses may be used, and after that, the client will be aware of their own strengths and weaknesses of their position, and therefore this will make them trying to settle their own dispute with negotiation. This negotiation did not succeed, both parties can allow intermediary to mediate the dispute or render a non-binding advisory opinion regarding the outcome of the case if it is to be tried in civil court. Usually, this method is commonly used by businesses and top management to resolve large-scale dispute involving million-dollar construction contract. Other than that, the federal government also make use of mini trial for dispute regarding telecommunication. Next, we go on further to settlement agreement. Settlement agreement is defined as a legally binding agreement between an employer and employee when an employer agrees to give up his or her right to pursue or bring future claims against the employer. Usually in this settlement, the employer will offer a sum of money in return. It is said that once settlement agreement have been signed, it cannot be changed and the employee will have no further claim against the employer. Basically, we can see that this agreement is usually used in connection with ending the employment, and it also can be used when employment is ongoing. But both of the parties want to settle a dispute between them. It is considered that a settlement agreement will be used when an employee is not performing well at their works and neither party wants to go through a long capability process. Here, both employer and employee are willing to bring the employment to a quick end on agreed financial term. In settlement agreement, the terms will be decided when there is mutually agreement between employer and employee. Next, the term will be set out in a written settlement agreement document that will identify the claim that have been made by the employee who agrees not to pursue exchange of agreement payment. In this agreement, they also have to include clearly expressed waiver of a particular claims which the employee has or could feasibly have. For instance, the term that could be included in this agreement are notice pay, bonuses, shares, value of termination payment, waiver and settlement of employment claim, tax, practical issue, legal costs, warranties from employees and reference. Therefore, we can see here that settlement agreements are very useful for ensuring the employer and employee dispute are concluded without the need for either side to resort to legal action. The law that relates to this agreement is a bit complicated and complex that makes the employee must take proper professional advice before they begin to go along the settlement agreement route. Next, I will talk about the advantages of alternative dispute resolution or ADR. Most of the time, dispute happen between parties can be resolved through this ADR. According to our research, we can see that only 5% of the time actually a case will go to the court. This is because many judges, attorneys and lawyers have encouraged use of method of ADR, and we can see that this trend will continue to grow because there are many reasons which why this process is used in many cases to resolve a dispute. The first advantage of ADR is it will improve the efficiency of the court. So we can see that in the court there are many number of cases that have to be settled. So it will significantly lower these cases if people in dispute all would settle the dispute outside of the court through all this method of ADR. They will also allow for cases which are more serious or complicated to enter court much quicker rather than their own cases that can be resolved without even going to the court. The second advantage of ADR is that it is consuming less cost and is very time efficient. So we know that litigation process is consuming a lot of time because there are many procedure and queue in the court that we have to follow. Therefore, we can see that it is more expensive because there are many costs of legal fees such as hiring a lawyer and the court costs if one loses the case. Also, by using ADR, it is less stressful due to the lower cost and shorter time. For example, if we use the mode of mini trial, we can see that it is speed up negotiation by making the cases is realistic. So both parties in dispute will see their cases played in the court and will be less likely to think over much less relevant and meaningless issue. Arbitration also can be another mode that can be used because it consumes less time and cost. Arbitration process or proceeding is shorter than court litigation because most private and judicial arbitration usually only take 4 to 5 months, while court litigation takes several years due to the amount of cases in queue in the court. Business community also preferred arbitration because most of the time their disputes are complicated and specialized. Therefore, it is important for the businesses to save their costs, minimizing delay of decision and also preserving the commercial goodwill of both parties. We can refer the case of Perbadanan Kemajuan Negeri Perak and Asian Security Paper Mills Sdn Bhd. Peh Swee Chin J stated that Arbitration Act, the very laudable purpose of resolving commercial dispute, bearing in mind at the same time the court have always worked more than they can ever handle. So we can see here that the court have a lot of cases that they have to resolve. Therefore, Arbitration Act is very useful when resolving a small commercial dispute. Also, if we use the mediation mode, the cost is less than the average cost in time and money for the litigation of a dispute. This is because the mediator hourly rate is lower than other legal counselor. Parties can also plan for the scheduled mediation between weeks or a decision in court order. The hourly rate for a mediator may be lower than to hire a solicitor. However, it is also noted that the mediator rate of price is depending on how experienced the mediator is. Some of the mediation services provide free of charge, as we can see in Malaysia Mediation Center. In Malaysia, some of the mediation services are free of charge. Therefore, many parties in dispute could use these services in order to settle their dispute by mediation method. Mediation method also saves time because mediation is a quick process that involving the coming into a mutual acceptable agreement to settle the dispute between both parties. Mediators also offer their services in evenings, weekends and regular weekdays. Therefore, this settlement will not take a lot of time, and this will give benefit to parties because this will be useful for them if they want to arrange session around their work time or family time. Okay, therefore, we can see that a resolution can be reached through mediation within 3 months and with fewer sessions than going to the court. The third advantage of ADR proceeding is that they are more confidential and handled in private, unlike formal settlement. Formal settlement are made public because in court everyone can come and see what is happening in their settlement, and this would expose the parties to embarrassing facts, allegations and any secrets that they want to keep. For example, in arbitration method, they offer confidentiality in their proceeding, and their award of arbitral are non-public and can be made confidential, and this will protect the reputation of a certain brand, and also both of the parties can exchange the information without being in the public domain. So the mediation method of ADR also is secret and private. Therefore, both parties will be comfortable because they might not want the world to know that they are going through a dispute. Because if businesses, they want to protect their reputation and having a high profile and public career, and also to avoid unnecessary embarrassment. The fourth advantage of ADR is the practice is very flexible. So we can see that in litigation, the procedure is very strict in the court. They have to follow each and every step in order to settle the dispute in the court. Therefore, only one of the person between plaintiff and defendant will come out victorious and win. However, if we use the ADR method, the risk of loss is less for both parties, which means that both of the parties can get the benefits from the mutual agreement and none will left with nothing. For example, if we use the arbitration method, parties can choose the appropriate law in the jurisdiction of their choice. They can also decide how their arbitration will work, including the arbitrators and procedures should be applied. They are also free to agree the procedure to be followed by arbitral tribunal in conducting the proceeding. The language to be used in arbitral proceeding also can be decided by both parties, but if they cannot come to an agreement, arbitral tribunal can decide for them. The location also can be determined, but this they will have to consult the arbitral tribunal.
All right, to move on to the fifth advantage of ADR, we have enforceability of the judgment. So when a reward, promise, or compensation is agreed among the parties, the agreement can be brought up to court if either of the parties fail to act on the agreement. So the agreement or the judgment made by the arbitrators are considered as a binding contract. To give an illustration right here, if person A agrees with person B to give 2,000 ringgit, and after some time has passed, person A did not provide this reward to person B, due to this agreement, person B can go to court and ask the court to settle this issue, and the court will automatically give this 2,000 ringgit to person B from person A because there was a binding contract, and arbitrators, the judgment of arbitrators are considered as fact, or not fact, but as a binding contract. This causes an advantage because it's a sense of certainty and security of the contract made between the two parties, or the judgment made by the arbitrator, meaning that the parties can't scam each other. They cannot run away from their legal responsibilities. Then we have neutrality and equality. Despite us knowing that the nature of ADR is informal, both parties can be rest assured that during the time of the arbitration or mediation, the person who mediates or arbitrates are trained professionals who are looking at this dispute. They're supposed to look at this dispute at a unbiased point of view. They cannot be biased. They have to be professional. They have to be reasonable. They have to be fair. One of the conditions of the arbitration is to be fair. Therefore, the arbitrator must act fairly during the period of arbitration. Later on, we will discuss about a case whereby, due to the fact that the arbitrator did not show that he was unbiased, the judgment was void. But that's another point. So, to add on, both parties would get the opportunity to represent their side. This is an additional point for this subpoint. They get to represent their side in a reasonable and fair manner. A specific amount of time would be given for the parties to inspect their documents, to formulate their arguments, to collect the evidences and property if it involves property, of course. To move on to point number 7, finality of judgment. This is more related towards arbitration. However, mediation can play a part, considering that it is some sort of, or can be considered as a contract between the two parties. So, when it comes to arbitration, the judgment made by the arbitrator is considered as a binding contract. Of course, this might sound a bit close to enforceability, but there's more differences to this point. It is incredibly difficult to appoint a judgment awarded by the arbitrator. For example, we use the case of Union of India versus Ralia Ram. To give summary of this case, the judge made or held that despite whether the arbitrator was wrong or right, it is not relevant in this situation. The decision made by the arbitrator is considered as legally binding, meaning that the person who is supposed to give that settlement claim, for example, maybe wealth or property, goods, etc., would still have to give that award despite there might be some sort of fallacy in the decision made by the arbitrator. But there is a point whereby the arbitrator can, or the judgment of the arbitrator can be appealed. This is in the case of Syarikat Perombong versus Federal Development, whereby the arbitrator showed a sense of biasness towards one side of the party. So the judge decided that the decision made by the arbitrator, if it was unfair and it was biased towards one party, it would not be considered as a legally binding contract, or it would be considered as void. It can be appealed, but it would be very difficult to do so. And then in the last point, number 8, we have effectiveness of ADR. Of course, we've been discussing for the past 7 points about the why ADR is very good, but this one is to pretty much to top it all off. Parties are typically more satisfied with the results imposed in ADR. Of course, this is mostly towards mediation, as they are able to raise up problems and concerns from both ends and provide more suitable reward. So, in terms of mediation, the parties are able to set up an agreement which are the most suitable in that situation, as there wouldn't be a third party interfering with the decision making. So, for example, like arbitration or when you go to court, there is this third entity which might take away from what both of the parties want. However, in a mediation session, the parties are able to provide an agreement which is suitable for the both of them. And in terms of arbitration, the effectiveness of it is that the parties are able to choose an arbitrator that has more knowledge and understanding regarding the issue. This is a clear, of course, effective. This is effective because the arbitrator that you pick can be knowledgeable and has a lot of understanding on the field that the dispute is, or the topic which is being held. Therefore, for example, like a judge, they might not be able to provide a judgment which is logical, well, accurate in a way, or reasonable, or the judge wouldn't understand the position of whereby the dispute would stand. But an arbitrator can be chosen by the two parties which know about this field, and the arbitrator can give a more accurate and a more knowledgeable type of judgment, rather comparing to a judge whereby.
Alright, so we already hear the most of alternative dispute resolution and its advantages by Mashita and Nick. Now, I will tell you what is litigation and its disadvantages that make ADR more advantageous over litigation. Here, I will tell you the definition of litigation. its process, and the disadvantages of litigation. Alright, so what is litigation? According to fine law attorney, litigation is defined as a process of resolving disputes by filing or answering a complaint through public court system. It is stated by federal court, litigation is governed by a number of federal rules such as Federal Rules of Civil Procedure, Federal Rules of Criminal Procedure, Federal Rules of Appellate Procedure, Federal Rules of Bankruptcy Procedure, and Federal Rules of Evidence. Meanwhile, according to Law Teacher Net, litigation is a contest between persons, organization, and state which is authorized by law in the court of justice for the purpose of enforcing legal rights. Here, it is stated that the case that brought before the court of law is called suit or lawsuit, and parties in this litigation process is called litigants, including plaintiff, defendant, applicant, petitioner, or respondent. Okay, now I will tell you the litigation process. So, the first one, litigation starts with pleading. What is pleading? Pleading is a lawsuit that files initial papers that have been done by each party that explain their side of the dispute. It begins when plaintiff files a complaint to the court and sends a copy to the defendant, as the plaintiff will describe what the defendant had done to plaintiff that caused harm to them. In this copy, plaintiff also will state the legal basis for defendant responsibility at that harm. After that, the defendant will be given specific amount of time for them to file an answer for that complaint, which is 30 days from receipt of complaint. This answer will provide defendant's side of the dispute, and they also will file counter claims against the plaintiff. Here, the defendant will allege that the plaintiff has harmed them and should be held liable for that harm. Sometimes, plaintiff also will respond to defendant's answer or counter claims by filing a reply. After both parties have completed the complaint, answer, and any reply, the issues for resolution by the court have been defined, and the litigation process will be continued to discovery. Okay, next process in litigation is discovery. Here, parties will gather relevant information from each other or from third parties that call research of the law, document review, and organization of witness interviews that can help clients and their lawyers assess the merits of claims and defense. During this process, the parties will ask each other and their third parties for information about the facts and issues of the case. After that, the information will be gathered formally through written questions, requests for copies of documents, and requests for admissions. And another method is in the discovery is depositions. Deposition is witness will be questioned under oath by parties' attorneys, and their answers are recorded by court reporter. It also will be used to learn more about the facts of a case and about the different witness content that had happened. Deposition also can use at trial to show inconsistencies in a witness story or to question the witness credibility. Furthermore, it also can be used at trial in place of a witness who cannot attend the trial in person. Alright, after the discovery had been done, the trial process will start. Here, the parties will present their evidence to support their claims or defense to jury or judge. But before the trial starts, each party will provide a document to judge that called brief, which are outlines of the arguments and evidence to be used at trial. Here, plaintiff will start and they will call their witness or introduce documents and exhibits to support its arguments. After each witness had been called and been questioned, the opposing party will have an opportunity to cross-examine with the witness. Once all evidence has been presented by the plaintiff and the defendant, both parties will give their closing arguments. After that, the court will instruct the jury on the law to be applied on evidence. Here, the jury will deliberate and reach a decision or verdict. It is stated that there are two types of trials in litigation process. The first one is bench trials. Here, it not involve a jury and the decision will be decided by the judge alone. The second one is jury trials. Jury trials is both parties will question potential jurors during a selection process known as voir dire. After the trial had been done, the litigation process is complete, but appeal might be held if a party dissatisfied with the result. Here, the parties will present their arguments in briefs which are submitted to the appellate court along with the record of evidence from the trial court. Here, the appellate court will announce its decision in a document that called an opinion. But it is stated that appeal process might take more than 1 year to be complete. So, after that, the litigation process had done. But it is said that litigation process had more disadvantages that make people does not choose this process to be held in the court. So, what are the disadvantages of litigation? Here, I will tell you there are 7 disadvantages of litigation, which are time-consuming, costly and financially, adversarial, advantages for wealthier parties, unsuited to disputes, no privacy, and damages the relationship. Alright, the first one, litigation is said to be time-consuming. Why litigation is time-consuming? It is because litigation needs to go through many steps and stages before the trial starts. And this process takes a long time to complete pre-trial stage, and the court process is very slow. It is stated that the pre-trial stage, which is discovery, really take a long time to have been complete because there are many processes that will be done in the discovery process. And the investigation in the litigation process is more focused on facts of the accident, the defendants, the injury, and ongoing medical treatment. So, this is the reason that make the lawyers and people very stressed at the litigation process and make them choose another methods to be held such as mediation, arbitration, and many more. Next, litigation is said to be very costly and financially. Why it is very costly and financially? It is stated that litigation is very costly based on 2 primary reasons, which is labor-intensive and time-consuming. Litigation is labor-intensive because it is more focused on lawyers' fees and expert witness fees. It is said that for a lawyer to be ready at trial, he must know every aspect or facet of the case and must be familiar with each and every document associated with the case. And it is stated that some lawyers estimate that they must spend at least 10 hours of preparation for litigation process. So, more skilled that lawyer with reputation and experience, more cost that will expected to be paid. Next, for witnesses, it will be more focused on the sheer number of witnesses to be interviewed and cross-examined. Next, litigation is costly because it is time-consuming. The pre-action stage of proceeding oftenly time-consuming and costly exercise. So, the cost will rise according to the length of pre-trial period as well as length of the trial. It means that the longer time takes to resolve the matter, the higher the litigation cost. Next, litigation is said to be adversarial. What is adversarial? Adversarial means that there is less regard to get a fair solution in litigation process. Here, the court decision might not be acceptable for either party, and it will result in disturbance of commercial relationship. So, there will be an adjudication of court result in a win-loss scenario, and it will be not mutually acceptable decision. Here, party who dissatisfied with the result may seek an appeal in following trial, but there is always possibility that the decision may be overturned by an appellate court that force the process to be redone over again, and it will become more costly. As I said before, the appeal process might take more than 1 year to be complete. Alright. Next, disadvantages for litigation. It is said that can give more advantages for wealthier parties. Why it is said like that? It said that litigation is not a process for solving problems, but it is a process for parties to win arguments. Here, wealthier parties will get more benefits because they are affordable to hire an experienced and good lawyer to engage in their lawsuit. When the lawyer is too good, judge and jury will easily be convinced from that good lawyer who has a strong convincing skill. In this case, even the wealthier party at the wrong side, they will easily win the litigation process because they hire a good lawyer to handle their case. This will give disadvantages to other parties that are not affordable to hire a good lawyer. Next disadvantages is litigation is unsuited to dispute technical issues. Here, judge or jury in litigation may not have enough knowledge and experience with subjects that matter of dispute between the parties. Jury are not law experts in this process, but they are common people. Because of this, they may not be able to make informed decisions about the case. And it is stated that the expertise might relate to physicians, accountants, engineers, economists, and other professions. So, the lack of knowledge by the jury and judge might result in wrong decisions in this litigation process. Alright, next, litigation is said to have no privacy. It is because court proceedings are never secret. Here, media will always cover the development in important cases that will become topic for public discussion that may bring notoriety, loss of goodwill, and long-standing reputation. It will make the parties become uncomfortable with the matter that they are being publicly. Lastly, litigation can damage the relationship between the parties. It is because the litigation result can be unpredictable and it will give no sense for the parties as the result of litigation sometimes can be favored by other parties. So, it can be difficult to the parties for overcome the animosity that can occur during the trial process. So, it can be very challenging for both parties to preserve any sort of relationship, either for them to be professional or personal, once the judgment has been handed down. So, the decision sometimes can end up with decisions that make no business sense. Here, the parties will get a legal win, but they must face significance of business losses. So, when parties want to enter the litigation process, they must consider that there will be no future business relationship between the opposition, as this will harm their future income. So, that's all for the disadvantages of litigation.
Right, so after all our group members have presented, we can conclude that litigation is not the only way to settle legal disputes. In fact, litigation is not even a preferred method by many people due to its high costs, it takes a lot of time, it's adversarial, its decisions are adversarial. The judges can have a lack of knowledge regarding the issue, and it has a high possibility of damaging relationships. And not to mention the possible burnout of like motivation or like work that the courts have to face and also lawyers have to face if litigation was the only option. The method of ADR outweighs litigation by threefold. considering that it is cheaper, time saving, non adversarial, safe, and reliable, does not affect relationships, and is flexible. Therefore, it is the preferred method, and that this the parties should use ADR to settle disputes, and they shouldn't even think about going into court, as the benefits of ADR are unmatchable, really. So, thank you for watching our video. Assalamualaikum warahmatullahi wabarakatuh.